back to is, what did we actually do when a member of our party had made a mess of things and been a disgrace in this office? You know, the governor and I and a few others stepped forward, took it on, and addressed it. You know, I didn't see anybody on the Republican side of the aisle ever do that when Bob Taft was convicted of crimes in office or with the Tom Noe scandals, nor did I ever hear anything from my opponents in this race. They never spoke out about Marc Dann until they became political candidates in this race. I and others actually did something. So at least, you know, that's a big part of the record here, I think. In terms of, you know, how I will handle things in the future, I think that's an indicator of it. You know, and you can judge me on my record of how I've handled things. I try to be very bipartisan. I try to be professional. Once, you know, elections are elections, but once you're governing, you know, I'm governing for Democrats and Republicans and independents alike. I'm working with officials on both sides of the aisle. I have a good relationship, I think, with the legislators and legislative leaders. They're mostly Republican right now. When I was in the legislature years ago, that was politics as I learned it. The Democrats at that time controlled the House, the Republicans controlled the Senate. It was George Voinovich's first term. And if you wanted to get things done, you worked with people and found common ground. And I think that's when government's effective. I think that's one of the things this governor's been pretty effective on. And, you know, I try to do the same.
Who was Attorney General when you were Solicitor?
Lee Fisher was the Attorney General. And then he was defeated by Betty Montgomery for election in 1994, which is when I went back out into private practice and had a private practice for the next 8 years before becoming county treasurer.
Can you tell us a little bit about your approach to open meetings and open records?
Sure. I am a strong proponent of open records and open meetings, and I've had occasion to practice what I preach in office. When I was a county treasurer, my baptism in this was that I was elected in 2002 and I was up for re-election in 2004. It was an unexpired term. So I was up for election in 2004, and my opponent at that time, his notion of conducting a campaign was to make a series of public records requests to my office virtually week in and week out. And I mean, they were extensive. I mean, there'd be 6, 8, 10 things, and then the next week or 2 weeks from then there'd be another list. And I was aggravated at first because I felt it was an abuse of the law. And we talked to the prosecutor's office about it, and they came to understand that it doesn't matter what the motivations are, it doesn't matter what the reasons are. Anybody who's a citizen has a right to know anything we're doing. And I took that to heart. We responded to all those requests. I never was bothered about them on the merits. I always felt that I thought our office was doing a good job, so I assumed that any records we disclosed would vindicate that, and they did. I was aggravated because my people had to spend a lot of time not doing their job, but dealing with that. But we did it, and actually over the period of the year I became a lot more cheerful about it because I think it did show we were doing a good job. We found ways to illustrate that we wouldn't have thought of because of this guy's zeal. When I became state treasurer in July of last year, the governor, I, Lieutenant Governor, Attorney General, Secretary of State, all received a public records request out of the blue that asked for every email to or from me during my first 6 months in office and a number of my staff. We learned pretty quickly the request came from a employee of the Ohio Republican Party, but it doesn't matter. It's a legitimate request. Everything that I do should be and is subject to public oversight. We burned a couple 100,000 emails onto a CD and gave it to them and go to it. I mean, I didn't feel that there were any problems that I was concerned about, and I always assumed that anytime I'm writing or saying anything having to do with my office, I should preface it with memorandum to the world, and it's fair enough. And that's the only way the public can know what's going on in their government. So as Attorney General, I will enforce that law from that point of view. And the Ohio Supreme Court has been tough on these issues over the years. They've been very stringent in enforcing that law, and I think that's appropriate. The Attorney General's other role here is the Attorney General does train local officials on public records law, and a lot of them are not very friendly to it. They just feel like, well, there's a lot of reasons there, but why should you know what I'm doing? Or I'll tell you when you should know something rather than you tell me. I mean, it's the basic principle is, who's the boss? Is it the official who got elected to office just because they happen to be there? Or is it the public who ultimately decide who they hire and have a right to know what's going on? It's clearly the public, and so that's how we will train local officials. And if there are controversies, we will push them to do what I believe is the right thing, even though that probably will be uncomfortable for them at times. So, and you should hold me to that. You know, if you find you're in controversies around the state and you think people are violating the law, obviously you can sue them, and if you win, you'll get your attorney's fees paid. But a lot better if people just comply with the law in the first instance, and I'll try to be helpful on those issues when they arise.
About the restrictions, along the same lines, the restrictions on, you know, names of concealed carry permit holders.
Yeah, that's a little harder because a lot of that is legislative. I mean, you're going to have to get after the legislature to change the law on that. I mean, I don't.
How about general print? I mean.